last, Henry Brown tells his story, and what a story it is. Far from being humdrum, Henry Brown's legal career has been packed with drama, intrigue, and long-term reform. His early law experience in Cape Town cast him into the eye of the struggle when he represented key anti-apartheid activists, including Nelson Mandela on Robben Island, Winnie Mandela, Zach de Beer, Albie Sachs, Robert Sobukwe, and many others.
Hi, this is Henry Brown. I'm going to read a letter that I received from Nelson Mandela in November 1966, which comprised his original instructions to me to act for him. It was addressed to Frank Bernard and Joffrey, PO Box 252, Cape Town, and marked "Attention, Mr. Brown. Dear Sir, I should be pleased if you would kindly appear for me at the Robben Island Prison Court on the 7th December 1966. As more fully appears in the attached summons, I am charged with contravening Prison Regulation 99(1)(b) and (d), as published in Government Gazette number 1326 of 31st December 1965, in that I disobeyed a lawful order or instruction of a member or special warder. Alternatively, that I was lazy or careless or negligent in my work, or that I refused to work, in that I refused to load the lorry after I had been ordered to do so by Major Kellerman. I should be pleased if your Mr. Brown will take the case. If Mr. Brown is unable to do so, kindly instruct Advocate Ahrens to appear. I have funds sufficient to cover fees. Yours faithfully, N.R. Mandela, signed Nelson Mandela.
Working with SWAPO and the International University Exchange Fund brought him into contact with the notorious government spy, Craig Williamson. Then, on moving to Britain, Henry rose to become a senior partner in a City of London law firm, gaining national and international recognition through his pioneering of mediation and alternative dispute resolution, with his objective to bring humanity and Ubuntu into the practice of law and the resolution of disputes. Distinguished former Constitutional Court Judge Albie Sachs writes of Henry Brown and his book. He says, "He tells an astonishingly rich and powerful story in a calm, low-key, and well-organized way, unusually unpretentious in a highly competitive and self-projecting profession." We asked Henry Brown to explain how he reconciles litigation and mediation.
Hi, I'm Henry Brown, and I want to touch in this little talk on some points that arise from my book, A Lawyer's Odyssey, Apartheid, Mandela and Beyond. I'm aware that we are living in really difficult and challenging times, very strange times, with political uncertainty, economic uncertainty, and arising from our, primarily at the moment, from the COVID pandemic that we're facing, also from the political uncertainties and economic uncertainties, and a huge environmental crisis facing us. These really are challenging moments for us, and I think we need to understand some points that are quite difficult. One of these arises, I think, in my book, and that's the issue that I was a committed civil rights lawyer in South Africa, and I did that work when I came to England, when I moved across to England and set up a practice, retrained as a lawyer and set up a practice here, and then became interested in mediation, in alternative dispute resolution, and in finding ways that people could resolve their issues without having to go to courts or to arbitration. And this gives rise, I guess, to the question, how do you reconcile the strong values you might have, the strong principles you might believe in, with the concept which is inherent in mediation, that you may have to compromise somewhere, may have to make some concessions somewhere? Can you reconcile these? This is a question that I've touched on in the book, and I mentioned an interview that took place, and I'm going to read a little bit from it, which was with Matthew Rushton in Mediation magazine, and it was in 2008, and he wrote, "Brown's journey from pugnacious civil rights champion to ADR, that's alternative dispute resolution, evangelist, might appear an incongruous one. It's not something that troubles Brown, however. If it is inconsistent, so be it, he says. If it's anomalous, well, life is complex. Brown sees a single clear path through all of his career. I don't feel there's an inconsistency between helping people find solutions to difficult concepts of all kinds and having a deeply held sense of fairness, justice, and humanity." And this is something which I want to just mention. When I represented Nelson Mandela for 4 years while he was on Robben Island, I think that when I look back decades later, I can see something that really important that I learned from him, and that was the ability to hold absolutely firm to your principles and yet to negotiate. I mentioned in the book about a court case which on the island, which I was indirectly involved in. I went over for it, couldn't stay for the whole case, as I've explained in the book, but I have since seen his whole talk. And on that particular occasion, he asked a magistrate to recuse himself because the magistrate came from a system that only appointed white magistrates, and that could not be fair. Mandela, in making that application for the magistrate to stand down, stood very firm on his principles, but was respectful to the magistrate as an individual, and he said he was challenging the system, not the magistrate. And I think he did it with incredible dignity, and more, and especially important in the knowledge that he had nothing to gain from it, since it was not going to succeed. There were no witnesses. It was just his own dignity that required him to make that request. But more importantly, many, many years later, when he negotiated with the nationalist government to establish a new society, he was opposed. And a lot of people would have said that he should not have negotiated. After all, how could you negotiate with a government, an apartheid government? And I briefly want to mention there's a book by Professor Robert Mnookin called Bargaining with the Devil, When to Negotiate, When to Fight. And Professor Mnookin says that there were two people in the 20th century who absolutely had historical relevance to this question. Churchill, because he refused to negotiate with Hitler, and Mandela, because he agreed to negotiate with de Klerk, with the government generally. And Mandela did not have to give up his principles. He was able to hold firm to those principles. He was able to stay true to his values and yet to negotiate. And I think this is something that we need to learn as people, that we can stand firm on principles, we can hold to our values, and we can find ways of working with other people so as to develop our connectedness, so as to create a better society. We don't have to be fighting one another when we have different values. There are ways, there are times when we mustn't negotiate, there are times when we should negotiate. And this, in a sense, talks to my development from being a lawyer involved in fighting cases through, even to the end. I continued fighting cases alongside the ones that we try to resolve by mediation. I'm not saying that they are inconsistent. They sit side by side next to one another. But there's an incredibly important principle involved. If we want to establish our connectedness, if we want to establish a better society, it's time for us to learn how to hang on to our values, hang on to our principles, and yet find ways of working with other people. I guess I just wanted to mention that in the context of how I moved from civil rights and general law litigation into accepting the fundamental principles of mediation and compromising where necessary and in an appropriate way. That's something that I think is really important for us all to reflect on, and I'm going to pause here and leave it at that for now. Thank you.